But I'm going to direct a question to Chris, and I guess this is a sort of framing question. I mean, what is the problem underlying the enforcement of second medical use patents, Chris?
Thanks, Peter. Yeah, so I mean, the key question in this area really is you have an old product being used in an old way, but it's for a new purpose. So how do you assess whether there's been an infringement? The difference really in purpose resides only in the mind of the user. And so the difficulties in answering this question have long been recognised. There was the House of Lords case and Merrill Down Norton in '96, but it actually wasn't until very recently that the UK courts have had to grapple with some of these issues, and that was the Warner Lambert pregabalin litigation that has been spoken about so much in recent years. And these, second medical use cases they raise issues which are sort of right at the nexus of regulatory and patent law. And that gives rise to lots of complicating factors. And so in second medical use cases, if you have a patented use on the label, that's a pretty straightforward case of infringement, whichever test you're going to apply. But the difficulties really start to arise in skinny labeling scenarios. So that's where you have the patented use not on the label, but the product is being prescribed and dispensed for the patented indication. And as you sort of rightly pointed out, the case law is a little bit messy in this area. So it's probably worth me at the outset spending a bit of time just explaining the background, dealing with the different kinds of claim you have, so Swiss form claims and EPC 2000 claims, and dealing with some of the sort of recent case law in this area as well as to how this issue has been approached.
So the thinking being that if the declaration is given, then the generic has a perfect shield. Either its product doesn't infringe for those indications, or the patent will be invalid. It's like a Gillette defense, and it's actually been quite topical in the UK over the past few years. It's come up before the Court of Appeal quite a number of times, fairly recently.